Let's take you on over here. Eskom and the Public Enterprises Minister Pravin Gordhan have been given an ultimatum to respond to a letter demanding load shedding be stopped. Civil society organizations, lawyers and political parties want answers by the 20th of January before deciding on possible legal action. This as other interested parties have made it known that they also will be heading to the courts. What are the prospects of these possible legal actions? We speak to Benedict Phiri, a legal expert on that. Benedict, thank you very much for availing yourself this afternoon. Perhaps let's start with your understanding of the possible legal action.
Yeah, when you look at the letter of demand sent to the minister and the CEO of Eskom, it's quite clear that the legal action that we anticipate or that will be mounted goes along the lines of the fact that in failing to provide electricity and the continuous load shedding, Eskom is undermining South African citizens' fundamental constitutional rights in the Bill of Rights. The letter sets them out quite specifically to say load shedding has resulted in a deterioration or reduction or a violation rather of the right to education, the right to life and health care, water, basic sanitation, food, access to courts, freedom and security, and obviously the right to make a living, which is the right of freedom of trade. And, you know, the letter gives some examples around the inability of citizens to effectively exercise those rights as a direct result of load shedding. So, you know, should this litigation materialize, we're going to see a constitutional attack on load shedding because it impacts negatively on citizens' exercise of their rights in the Bill of Rights.
The letter also has a number of demands. So we're in possession of the letter by Mabuza attorneys addressed to the Public Enterprises Minister as well as the CEO of Eskom. One of the demands also includes the deal that South Africa entered into with the United States, where the President of the US, Joe Biden, committed some 8 billion rand worth of loans to the country to assist with the shift to coal, or the shift from coal, I beg your pardon. And they mentioned that this is particularly so because it has also been reported that South Africa's coal exports have increased by 700%. So the clients, which are stated here, do not understand the nature of the commitment that the country has entered into with the United States. What do we need to understand about that? Did it even have to get to the courts for South Africans to get this kind of information?
Well, I don't think they'll be able to exercise that right immediately through this particular court action, because we do have the Promotion of Access to Information Act, which provides a remedy for the obtaining of information from parties, private parties and public parties. And certainly I think if that was what they required in the first instance from the court, I think the court would ask, how come you haven't tried to request that information through the legislative scheme to allow for that? So, I don't think that would be part of the challenge initially, because I would expect that at the very least, we would see a request under the Promotion of Access to Information Act, and only if that has not been dealt with within the framework of that act, then there would be a challenge to the courts.
NUMSA is also one of the clients, and they're particularly concerned about the impact of closures of power stations on employment. Prospects of success there?
I think that would fit into the broad rubric of the exercise of the right of freedom of profession. I think, when you think of the ability to be able to be in a profession or undertake a professional work, it is a right that is bestowed upon citizens, and I think they would try and make that argument under that rubric. I mean, obviously we have to see what the court papers eventually look like. They will look very different from the letter of demand, but provided that it is properly framed and comes within the test for the violation of that right, there might be prospects of success. I don't think the threatened action is frivolous at all. I think, in fact, provided the court papers are prepared properly, this is actually an important piece of litigation insofar as the constitutional right to give effect, or rather the obligation on state and state entities to give effect to constitutional rights.
So the law firm further notes that we are instructed to demand further that the state should provide the following undertakings: that there will be no load shedding without procedural fairness and a fair opportunity to make alternative arrangements to affected persons and businesses. What is fair, right? Because Eskom will say, well, we always make it known, even if it's at a whim, that we are moving into stage 6 at 5 a.m. tomorrow, or stage 4 at 5 a.m. tomorrow. So how to determine fairness?
I actually think that that's part of one of the weaker parts of this particular letter, because I don't think that it is a straightforward argument that citizens have a right to procedural fairness in respect of load shedding, just given the manner in which Eskom operates and the policy implications and inputs that would go into that. From a read of the letter, it seems that it's hinged on the basis of a legitimate expectation, which we obviously know is actionable if your legitimate expectations are violated or not met from a state institution. But I don't think that it would work to belabor a state organization such as Eskom and others with the requirement to give citizens a fair right to actually deal with load shedding before it's actually done. So I think that would be the weaker aspects if the court case proceeded on that basis as a point of attack.
What about this aspect, that load shedding will stop with immediate effect, and if not, a full explanation about why the government is unable to stop load shedding with immediate effect, that the state will thoroughly and lawfully create mechanisms, make reasonable disclosures to the public on the challenges driving the energy crisis and the solutions implemented to solve it. The president delivered his plan, which included renewables, which included the just energy transition. Eskom is always making us understand that there's sabotage at the company. They're dealing with corruption and things are being dealt with. So is there an argument to be made about these points?
I certainly think it was wishful thinking to think that there'd be an immediate end to load shedding. So I think that demand was not necessarily well placed. However, if you think about the fact that constitutional rights are at stake, and that for a limitation of fundamental rights in the Bill of Rights, there needs to be a real proper justification for that. I think the request that a plan be put in place and it be shared with South Africans around how load shedding will be dealt with in future and that be interrogated goes to the question of whether our constitutional rights can be properly or justifiably limited in this particular manner. So I think that is a well-placed request, and you can see where it goes to, because essentially what the litigants are requesting is to test whether it is justifiable to limit constitutional rights which they allege are violated in this particular manner.
Benedict Phiri is a legal expert. Thank you very much for helping us make sense of all of that.